back to the TechLaw Solutions booth with Browning Marean and Tom O'Connor in the e-discovery zone. Our special guest this morning is Craig Harnack, the Magnificent Ball, who has deigned to join us. This is a reference to a small appearance Craig made last night at a party put on by Fios, and he made some predictions, along with several other people, about what we'd see in the market. What were your predictions for those who didn't attend that dinner?
Well, my predictions last night, the more serious ones, were, and I'm very happy development is really seeing some genuine improvement in the quality of education and e-discovery. You know, we've been hovering at somewhere between 10 and 30,000 feet, to the point that I think there's some saturation. People have heard all they want to hear, and there are a handful of pioneers who are ready to go further. We don't know how many are really ready to embrace technology. There's still legions of lawyers saying we surely don't need to know this stuff, and looking for the loopholes to get out of it. You guys know it, but I'm preaching to the choir. And let me say, ladies and gentlemen, this is a great privilege for me. These are my two very best friends in this industry, and being with them is the best part of your day and mine. So,
well, you know, a little bit of history, if you'll recall, Craig, you were our first victim for e-discovery.
The first person to enter the e-discovery zone.
I was, and I've noticed that I've never been asked back into the zone until this moment. And it's just very wise, which is why probably the zone has remained such a great success. But after that false start, the zone is just full of good information. When I go to the TechLaw Solutions site, you guys have just reams of wonderful interviews.
Thank you.
And I especially enjoyed your last video, the one you did at the ILTA conference last year at the ARIA. That was great.
With Dwayne Lights.
Yeah, Dwayne did a great job.
Dwayne's a good guy.
So
yes.
I highly recommend perusing their content, either by your podcast.
Yes.
Load them to your
Actually,
iPad,
Jay
iPod.
Stromberg, who's the actual manager at TechLaw Solutions, who keeps us herded together and somewhat well-behaved, told me just this morning, and I didn't know that we're available now on iTunes. I know you've got some things planned for this summer.
I do, and
what
I'm
you
very
can't
excited.
share, please tell us about it.
Oh, I'm very excited about it. You know, Georgetown University Law School has been a real trailblazer in e-discovery education for a long time. Their e-discovery institute, I think, is second to none in terms of the caliber and quality of people that come every year for 2 days, especially the judicial participation. Well, Larry Center, who runs that CLE program, is trying to revitalize and change the Academy program, which has been around for about 2 years. And I was involved in its original iteration and then sort of fell out of the process. And I'm back now with Judges Grimm and Fasciola and Mike Arkfeld. And all of you know all these folks really well. And I mean, I think of Mike as the dean of e-discovery. His treatise is the best there in the business. And so collectively, that small crew and also a forensics trainer, we're going to sit for 5 days with no more than 50 people, and with hands-on exercises, labs, me droning on with my endless PowerPoint animated slide decks and everything else, Mike's brilliance and everything, and the hammer of 2 federal judges who will be there every day to make sure that you really get what they need you to know. And that's a big thing.
Not just 2 federal judges, but 2 who are right at the front of developing the standards for this area.
Head of the class, and truly, and great guys too.
Okay.
So that's the plan, and those 50 people it's going to be rigorous. It's going to be hard. We're going to have an exam. We're going to have exercises. We're going to have them hands-on with tools, doing things that they've been having vendors do. I mean, you're going to know what hashing is. You're going to make hash sets. You're going to refine searches. You're going to get in there from the moment that data is born as a bit on the magnetic media until it emerges as terabytes across an enterprise. You're going to know it every step of the way. It's the most ambitious educational week I think that's ever been attempted in our space, certainly, and it's a lot to do. We've set big goals for ourselves, but I think that if we have 50 motivated people who have said, you know, I know enough about this stuff, but I really realize I want to know the technology. I want For me, it's going to be as much as I can, a brain dump of everything I know. Mike's going to do the same. Others are going to do the same. And hopefully after that 5 days, people are going to say, that was brutal, but I feel ready. I feel like I have the foundation I need to start teaching myself what I need to know.
Now, do you think you're going to go, is that going to be targeted more at lawyers, or, we've got large firms like mine, we have lit support folks that could, both could benefit from it.
And IT folks too, because we do plan to obviously teach the law of e-discovery too. We're not going to emphasize its CLE component in the same way it has been done.
Okay.
The thing is, if you're a lawyer, you already have the skills you need to go out and find the law of e-discovery and master it. We don't need to show you the path to the law.
Right.
We'll have that for litigation support people, we'll have that for IT people, and the twist, and I credit Mike Arkfeld with this, the twist is we're going to have some role reversal. We're going to train the IT people to play the roles of the lawyers. Now, don't get me wrong, we're not going to try to make them lawyers, but to help them walk in the moccasins for a while. And the lawyers are going to have to play the role of the IT people in some exercises so that we can begin to develop their ability to communicate with each other.
Will there be video available of those lawyers playing IT people? Because I would pay to see that.
This is a drama, not a comedy, actually. I think we appreciate that early on there'll be the usual posturing, but we think by the end of 5 days of this, they're going to get it.
Okay.
And they'll be able to know enough about the other person's role to be able to use them as a resource. And if we can build in them this ability to say, I'm going to go talk to IT, and I now know how to frame the questions with the right language, with the right precision, that they get what I need from them, that I think that communication is essential. Because I think you guys would agree, communication and cooperation are the missing ingredients of how we do e-discovery, and very little is more effective at reducing the cost.
Right. Is there some place where the folks can get information about this?
Sure. At the Georgetown Law School, the Georgetown Law School CLE website. I know that Larry Center is putting together promotional materials for it now, but if you're interested, please reserve the first week in June of 2011. Because frankly, if you can stomach being with me for a week, the benefits you'll get is big with Judges Fasciola and Grimm and with Mike Arkfeld and other stellar instructors. And I'm hoping, Tom, you will come up and visit as well, because
would love to participate.
I really want somebody out there, because we understand that this isn't going to come easy to everybody, and the secret weapon would be having somebody like Tom who could be out there working one-on-one to help people stay up with the program. And I'm really hoping that we can work it out with you to come and do it.
It'd be my great pleasure.
And mine too, to have you there.
Now let me turn the tables on both of you, because I know that both of you have been representing separate camps in a marvelous little dogfight. I won't go into the specifics of it, but how are you finding when you get into these situations where you've got two sides that there's been a breakdown in communication? It seems to me having somebody knowledgeable at both ends can really help in that communication gap. Does it work? What makes it work? Where does it fall apart?
Despite appearances to the contrary, we were not actually on opposite sides. I was the neutral special master.
In a sartorial sense. Yeah.
Okay. Yes.
Craig was actually the special master.
Okay.
And I was working with one of the parties.
But I find it a fascinating and now unfortunately necessary role as the judiciary comes up to speed, but really doesn't have the time when you're dealing with what, from all appearances, is a discovery train wreck. How do you get the wheels back on that?
Well, here's my comment based on not just that matter, but a second one, which is in the first matter that you referred to. Both Craig and myself, Craig by the court and myself by one of the parties, were engaged very, very late in the process. The case had literally been going on for years at various levels of participation and in several different jurisdictions. And so at that point, you're right. If it's not a train wreck per se, it's very, very difficult to get people who have already built up whatever their relationships are with the opposing counsel and their methods of dealing with each other and the court, those are, if not set in stone, they're very well established. A later case that I just had a fairly small role in, where Craig was also a special master, he was engaged very early on in the process, was able to develop an exchange protocol that all the parties in the room, and literally there was a meeting that I attended where there must have been 20, 25 parties were represented. Everybody had a say on the protocol. Everybody pitched in on the protocol. Everybody was heard with equal voice on what they wanted to do. And that's been going fairly well. I wouldn't say it's not without bumps, yes, but
sure,
the earlier the better. To get that communication going, to get that agreement, and to have somebody like Craig who can push that forward when folks aren't real clear on all the terminology, on all the technology, to help them explain and where perhaps people might tend to butt heads, someone can help them say, well, no, wait, there's really nothing to argue about here. Let's look at it from a little different perspective. That, to me, is the big difference.
Yeah. Well, and I think it's the great hope, particularly in some of these larger cases where you've got a lot of moving parts. And it's I think it's pretty easy for lawyers, for one reason or another, to major in minor things, and a lot of some of the things that we need to come to agreement on, having a knowledgeable and honest guide to the whole process, I think is a great solution.
Well, there's no question, and they're both pending matters, so I obviously can't comment on them.
Right.
I will say that, you know, one of the great assets I had in my role is having someone like Tom, who I had confidence understood the technology, but more than that, and you guys understand this better than anybody, you could trust what they said, you could take it to the bank.
Sure.
And so the wisdom of getting someone like Tom or you or George Sosha or any number of people that are here in legions at this point, although they're not as many as we need, bringing those person who are technically adept but who understand how litigation works in, getting us in a room, getting the technically adept people talking to one another. You know, I've found the more a lawyer knows about e-discovery, and especially about the technology, the fewer areas of disagreement there are. Much of what we argue about in e-discovery grows out of ignorance, and much waste grows out of that ignorance too.
Well, I also, a little confession, I'm on the ABA Tech Show board.
Much to the credit of the ABA.
And I want you to, everybody, to get on your calendar coming to Chicago. Craig has agreed to come and do his PowerPoint presentation. And if you have not seen it, you are really missing out on the true master.
Well, thank you. Just to be clear, if you've seen me, you've seen a PowerPoint presentation. This presentation is about how to use PowerPoint to communicate and persuade. So it's me talking about PowerPoint and how it assists lawyers in communicating information, complex information, technological information, and emotional information in visual persuasion.
Right.
And we're really looking forward.
Well, thanks for that plug.
Let me just throw a little plug in for that. As a former
How
member
much is this going to cost me, gentlemen?
As a former member of the Tech Show board, I happen to be on the board. I believe the last time you gave that presentation, and Greg doesn't like to talk about this too much, but he actually received the only perfect score from all the Russian judges in the audience in the history of the Tech Show. And this is, I believe, the 25th year of the Tech Show?
This is the 25th
year. So it is, in my mind, very fitting and extremely helpful, especially in the days of increased need for better communications. If you're available to go to Tech Show to see this presentation, you should see it. Well,
if you're available to go to Tech Show, there's so many presentations that are there to see.
Well, thank you very much for stopping by, Craig. We appreciate it.
Great privilege.
Look forward to seeing more of your presentations here at Legal Tech New York. Thank you again to TechLaw Solutions. And that'll be it for now from the e-Discovery Zone.
Thanks.